keeping you awake after lunch talking about the law. So the good news is it's very interesting and exciting, so I have that on my side. But the reality is that one of the biggest limitations for how we are going to protect, plan, and use our water in Texas is really limited by two major things. One is the science, which we talked about in the morning. The second thing is the law. So it's very easy to say, why can't we just blah, blah, blah? But we have a lot of laws in place that may affect what it is that you want to do. And I will tell you that Texas groundwater law will make your head hurt. So if you've never dealt with this before, buckle down. It's weird. And we have about 3 different things going on at the same time. And so this really is a super crash course in understanding the basics of how we regulate groundwater in Texas and its relationship to private property rights. So the first thing that I would say is when I teach water law, the first thing that I ask my students is, why do we have water law? What is it that we're doing here? Almost always the first answer is protect or manage the water resource. Many of you know that's completely false. Texas water law is a property rights legal regime, and that is what it is there for. So that can cause conflicts when we are trying to ensure that those water resources are going to be there over time. And so really, don't expect anything that talks about, the word sustainability. We do have some planning things in place, but true water law and the cases that have generated it really have more to do with property rights than anything else. You heard this most of the morning. What is groundwater? One of the challenges with water law is that we have a miscommunication between the science community and the legal community. And we use words very, very differently. So words that I used when I was getting my hydrogeology degree are very different than the words that I use, or they mean totally different things in the legal regime. So that conversation has not been horribly successful. So from a water standpoint, when we talk about geology, we're usually talking about the words aquifer. When you move into the legal regime, you don't see the word aquifer here, right? So the legal definition of groundwater, because in the law we first like to define what it is that we're regulating. And so we have a definition for surface water, we have a definition for groundwater. Most scientists would call a water-bearing permeable formation an aquifer, but note that we don't use that word in the law. But this is what we mean by legal groundwater. So all the laws I'm talking about will pertain to these types of things. So not to belabor this, but these are our minor and major aquifers in Texas. So if you're not from this area and you want to see what is in your area, all of these are available online. This is where our groundwater does come from in Texas. So most people are familiar with the Ogallala, which is a very large aquifer up in the Panhandle. I spend a lot of my time on the Edwards, which is that blue sliver that's pretty small that feeds or sustains many millions of people. So how do we manage and allocate groundwater in Texas? Well, the first thing we have to do is we have to juxtapose it to how we do surface water. So I'm not going to talk a lot about this, but we do need to talk about it a little because the systems are so completely different. And so the definition of surface water for Texas is here. We actually don't call it surface water, we call it state water. And we call it state water because these are the waters that qualify for state regulation. So if you are using state water, in most cases you are going to need to get a permit. And so it's really what we think about as natural rivers and lakes and things like that. That also is complicated, but we're not going to worry about it today. So the main thing about surface water is most people don't recognize that the owners of surface water are you and I, the citizens of Texas. We own the surface water. It is held in trust by the state, who then permits and gives use permits to applicants. But their job, the water in Texas, surface water, is really part of the public trust. So there is a notion of shared ownership, shared goals. You see a little bit more in the regulations here about sustainability, thinking about the health of the bays and estuaries, which you're going to hear about by the next speaker, that those things matter. groundwater is completely different, okay? So I'm gonna run through how we got to where we are. And nothing happened for a long time. There was no law on groundwater until the early 1900s. We saw our first groundwater case, which is often referred to as the East case. And Mr. East had a well, and by the way, this fact pattern is extremely similar to most groundwater cases, as you might imagine, right? Non-lawyers can figure this out. I have a well, what's gonna happen? Somebody's gonna put a well next to mine that's gonna mess with my well, and that's gonna make me mad, right? So if you boil down groundwater law, there you are. So Mr. East had a well he used for personal use in agriculture and things like that. The railroad company put in a massive well next to his and pumped it dry. The case went to the Texas Supreme Court. It was what we call a case of first impression. There were no laws on the books and there had been no cases. So the court had to look around to determine which theory of groundwater law it was going to follow. And it decided to go look at English law. And I don't know if any of you have been to England, but the rain and the atmosphere and the climate are very, very different than what you see outside. Regardless, England had a law of capture, which is that the water rights attached to the surface ownership, and if you had surface ownership, you could capture that water. And so the court said, that's as good as anything. And the reason that they did that was, one, it was easy to find, and it worked for England, but two, they were really freaked out by the difficulty of trying to predict and understand groundwater, right? They talked about it as secret and occult. We don't really know what's down there. We don't think we can effectively do anything. If the legislature wants to do something different, they can, but for now, this is what we're doing, okay? That was the decision they made. They also made it for economic reasons. Oh, thank God, that thing's driving me crazy. They also made it for economic reasons. They said, we don't really want to limit groundwater pumping because that could have a negative effect on the economies of the state, and we don't want to interfere with that. So this very powerful case is about a 3 to 5 page long opinion, and we have been living with its legacy ever since. So for almost 100 years, this was the case that we had. Of course, there were other water cases, but there wasn't anything that directly questioned whether right of capture was what we wanted to continue with until the late 90s when the Cipriano case came along. If you drink Ozarka water, every time I teach this class, in my class, I look around, there's always like 10 Ozarka bottles, right? So I blame them. And very similar fact pattern, right? A family had a well. This water bottling company came in and was taking out huge amounts of water for bottling and export. They came before the Texas Supreme Court and said, this right of capture thing is not working. You must abandon it and put in something called reasonable use, which means that everybody would have a share to a reasonable amount, reasonable under the circumstances. A lot of states have this groundwater regime. Well, what the court did was they looked at this and they were actually pretty critical of right of capture, particularly the dissent, and said, you know, right of capture is just not going to work going forward, but it's really not our job to change it, it's the legislature's. And the timing of this case was so critical because it was after the first omnibus water bill. We've had 3, so this was after Senate Bill 1, which basically had just finished, the legislature had just reviewed the right of capture, and instead of undoing it said, we're going to use groundwater districts, which I'll get into in a minute. So the court said, look, this is really the legislature's purview. They looked at it, they decided to stick with what they had, we're not going to change it. And so for now, it's right of capture, and oh, by the way, we don't think it's a very good idea. But that's where courts defer to the legislature. So what does absolute ownership or right of capture mean after Cipriano? Well, it meant that a landowner has a right to extract groundwater from beneath their property and use it for any purpose on or off the property. So there was no tie to where you were going to use it. You could also sell it, lease it, transport it, will it, gift it, all of those things, right? So when you have a bundle of sticks of property, that was part of it. The only exceptions to this were you couldn't be mean, couldn't do malicious things, you couldn't waste, and you couldn't be negligent. Now it's interesting, these limitations still exist, and what's interesting is that we really never have litigated what these mean. So the limitations are there, but we really don't have the boundaries of what would be included in, say, waste. But that's what we have. We even have, you don't have to read all this, it's very boring, but it's just here to show you that we have these very detailed definitions of waste, and yet we don't really do much about it, right? So when we talk about the groundwater districts, when Sarah talks about that later, you know, that might be part of their analysis, but we don't have a lot of litigation rotating around this notion of waste. So that's where we were in 1999, was right of capture is here. If you owned land, you got the water beneath it. But there is a layer on top of that that all of you are probably already familiar with, and that is the groundwater conservation districts, right? So in the absence of a water conservation district, to this day, it is right of capture, 100%. So we call those the white areas. Any of the areas that don't have groundwater district, it goes by the Cipriano case and a new case that I'm going to talk about right now, or in just a minute. Within a groundwater district, though, from much before Cipriano, we had this notion of groundwater district, which is a bottom-up regional local approach that says, you're the folks that know your groundwater the most, you know how it should be used, so you get local control. If you want to come together and create a groundwater district, you are empowered to manage that groundwater system within limitations. Well, what Senate Bill 1 had done right before Cipriano was they put all their eggs in that basket. So they said groundwater districts really are our preferred method of groundwater management, and they strengthened the different types of things that a groundwater district could do. And not coincidentally, we had a proliferation of groundwater districts immediately after that ruling. Now, it does not take a genius to figure out that the little colors here do not match the colors on, now I'm going to be annoying and be this person that goes back and forth, doesn't match that. So we have many, many groundwater districts in many places overlying the same aquifer. And this is leading to some challenges, which I will talk about when I talk about the regional planning process. But that is how we move forward, and that is how we've moved forward really until now. And we're going to talk extensively about the groundwater districts and the power that they have, and why when you're looking for a tool, this is the very first one that you can and should start with. So what was it that groundwater districts were supposed to do? Well, the beginning of their purpose says that they are conservation, preservation, protection, recharging, and prevention of waste. So now, remember I told you that property rights really are at the center of groundwater law, and not really preservation or protection. Now we have this layer where they have the authority to be thinking about, and later on they get added the obligation to think about, the protection of the resource itself. And so some of the things they can do, this is the list of beneficial purposes, so they're not supposed to permit anything that isn't for a beneficial use. Now, we could have a conversation all day about what constitutes beneficial uses. Generally speaking, beneficial uses are meant to change with the, not only change, but reflect the values of that society. So for an example, in Colorado, one of the listed beneficial uses in the law is snowmaking, right? We don't have that in Texas for obvious reasons. And so it's always fun to talk about beneficial use. So most of you, if we had had time and I called on you like I do my students, we would have come up with a very similar list to this, right? It's usually domestic use, growing things, agricultural industry. One of the interesting things is that we haven't really moved into is, do we have a real priority for these? Are there things that we want to say no to in favor of other things? And that is different in surface water. So these are the types of rulemaking powers that a groundwater district has, right? They have, and most of you are probably familiar with this, they have some permitting authority. They can do things, they can really manage well interference when you have two wells next to each other, spacing. One of the biggest legal battles going on now is, can they limit the amount of water that is going to be exported out of the district? There's a lot of districts that would really, and citizens of those districts that would really like it if they could just say, yeah, you can have a permit because you live here, but you are not to sell it to somebody else that's going to take it away. But think about what the purpose of right of capture is and ask yourself if that's consistent with the law. Right of capture is supposed to be a full bundle of sticks. You have absolute ownership of that property that you can sell, and so the law really does not permit or allow a groundwater district to be that limiting in how they use water. This is sort of where the new frontier of the legal battles and conversations are going, is sort of looking at in the district versus out of the district. So after Cipriano, the groundwater districts kind of went along, and they were, different districts promulgated different types of regulations, and some did a great job, and some did very little, and then you had all these places that weren't regulating the groundwater at all. And then we had this very special groundwater district that's different from all the other groundwater districts, and that's the Edwards Aquifer Authority. And for those of you who are unfamiliar with how this came to pass, the Sierra Club sued Fish and Wildlife because there were many endangered species that were living in the springs that were fed by the Edwards Aquifer. And at that time, San Antonio was growing very quickly. The area around San Antonio, so really nothing's changed, by the way, because it's still growing. Those are some of the fastest growing counties. And the amount of water they were using were starting to dry up the springs, and they were not managing effectively. There were a couple of groundwater districts in existence, but they weren't really doing much. And so the Sierra Club sued the Fish and Wildlife Department and said, you're not doing your job. You're risking endangered species by not forcing these groundwater districts to manage the aquifer in a way that's protective of those species. And they won. And a federal judge in Midland said, if you don't get it together, the federal government's going to come in and we're going to manage that aquifer for you. Never have you seen the legislature move so fast. Generally, for those of you who have had the horrible experience of going through legislative session, it takes 3 to 4 legislative sessions to have anything happen. Between the ruling of this case and the Edwards Aquifer Authority Act was about 2 months. That's how little they did not want the federal government to come in. So they created a groundwater district that was different from all other districts because it had a pumping cap. It said, you cannot, they did the math, they figured out where the Edwards Aquifer level, potentiometric surface needed to be for the flows to continue and keep up the health of the springs. And they said, okay, well you can't pump more than this, and you needed to have drought plans. And then there was this limited number of permits. So I always like to think of this as musical chairs, right? There's a whole area of people that have been using this water over time, and they're very distinct districts. So you have San Antonio, that was by far the biggest user. 100% of their municipal water supply came from the Edwards. But then you had the entire western agricultural portion also depending on that water. So they came up with a formula, I will not get into it, but it used historic use, which is if you've been using this water this way, then you are entitled to a certain amount based on that. Because if your water isn't regulated, you probably don't have a pump associated with it and a meter, so you can't say how much you've been using. So they did something, you know, like 2 acre-feet per acre, and you had to prove up that you used it during a certain period of time. And once the permits were gone, they were gone, right? So everybody grabbed a chair, the music stopped playing. If you weren't sitting down, out you went, right? You could buy a chair from your friend, but there were no more chairs to go around. Well, that was considerably different than what we see in other groundwater districts at that time, which were basically either not allocating or just giving a permit when it was asked. So this then triggered this question of, hang on, if I have ownership of my groundwater, and because I'm a surface owner, and I go to this Edwards Aquifer Authority, and I say, look, I own X number of acres, I need a permit for this amount, and they say no, how does that work? I thought I owned it, so how is it that they can tell me that I can't? Well, so there was this little legal wrinkle that hadn't been resolved by any case previously, which is, does absolute ownership mean that you own the little molecules in place as you sit there, or do you own the right to go get them? And that little distinction makes a huge difference when it comes to property rights and whether or not you have the potential of a Fifth Amendment takings. So think of it this way. You have a house with a front yard and a sidewalk. If the government comes in and says, yeah, I'm gonna need the first 5 feet of your front yard, everybody knows they can't do that without paying you, right? And they have to prove something up to even be able to get to the point of paying you. So this issue started to come up in the Edmonds specifically because there was a cap. So there were people that were getting a straight up no, right? I want this amount of water. Sorry, it's all been given away, see you later. And so one family brought a case, the Day family, it's actually the Day family and the McDaniels family. And here are the facts of the case. They applied for a permit to pump 700 acre feet. Remember, an acre feet is the amount of water to cover 1 acre, 1 foot deep. So imagine a football field 1 foot deep. It is a lot of water. So they asked for a lot of water to have pecan farms based on what they thought was historic use permissible under the act. The problem was they didn't really have a groundwater well that was pumping and doing this. They had some overland flow that was flowing into a surface water lake, and they had some groundwater running into it. So after the Edwards did their analysis, they said, you know what? You were not irrigating this with groundwater. You do not qualify for the full 700 acre feet. Instead, we're going to give you 14, right? Well, this did not go over well, and they sued saying that it was a takings, that they were denied a critical part of their property right associated with their surface right because they were denied the water that they needed to use the land in the way that it had previously been used. Well, this case took, and by the way, if you're thinking about doing a takings case, you should know this, they run anywhere from 10 to 15 years. They are very long and arduous, so you've got to really want it. In fact, unfortunately, the original plaintiff had died by the time the ruling came through. So, you know, eat well during this so you can be around for your big win. And so what the Texas Supreme, it went up and back down, and anyways, it finally ended up in the Texas Supreme Court. And the oral arguments were heard in 2010. We did not get a ruling for almost 2 years. That's how little the Texas Supreme Court wanted to get into this. And in fact, not to totally dork out on you, but there have been several other cases where the court had the opportunity to get into this and it sidestepped it every which way. But in this case, it was such a direct lineup that they just had to answer the legal question. And the way they answered it was, you have ownership in place. And what they said was, look, we're going to look to oil and gas law, which is similar here, and we're just going to do it for the most part the same way. And so you have in place those rights. Well, you can imagine how the groundwater districts, environmentalists, sustainability proponents felt about this, because on the one hand, there was this recognition of private property rights, but what about the neighbor's private property rights that doesn't want all of their water to be pumped out from under them? They got nothing, right? So to be clear, there is no liability between users under right of capture. If your neighbor pumps you dry, that's just how it is, because you also had the right to go do that, but you didn't. So this can create some neighborly challenges, as you might expect. While we were waiting for the Day case to come through, the legislature got very nervous because nobody knew which way the Texas Supreme Court was going to go. And so they then passed this piece of legislation that, to my mind, tells us nothing that we didn't already know. So here's when you know that they're being obtuse, when both sides think they won, right? So the original version of this bill said ownership in place, which is a very clear determination of what the legal question was. The final version did not say that. It said, we have right of capture. Well, we all knew that. And so both sides said victory, and then we waited for the Texas Supreme Court, and they said ownership in place. So this is sort of the lead up to this. What the Day case did not say is what constitutes a taking. So because they said there's ownership in place, what they were ostensibly saying is too much regulation would result in a taking. But we're not going to tell you what too much is, right? So it very much was very, very clear that the groundwater districts can still do their thing, right? Otherwise, you'd just be doing away with all these years and years of groundwater district legislation. They said, well, they can, but they just can't do it too much. So what does that mean? Well, think about, for those of you who have lived or do live in a city, think about zoning, right? That's the easiest thing that you can think about. we all know that there are limitations that can be put on how we use our homes when we're in a municipal area, right? They can tell us not to run an auto mechanic shop out of our garage. They can tell us, that we can't build our house right on the street. All those things are perfectly legal. And so one of the interesting things that came out of the Day case was, it's my property, you can't regulate it. Since when has that ever been true, right? There's all kinds of regulations on our private property. What they cannot do is take a critical part, they can't over-regulate and take a critical part of your rights without paying you for it. So Day teed up this question for us, which is, oh great, now we know you can get a takings, but none of us know what it is. And I will tell you that takings litigation is always, whether it be water or anything else, is always an ad hoc inquiry. It's always very, very specific to the facts of that case. So the only way we're ever really going to understand what constitutes a takings is to have a lot of litigation and say, okay, we know this is a takings, and we know this over here is not a takings, and then you try to figure out where in that spectrum you are, right? So the first case that we had that worked its way up, because it had been in the courts actually for forever also, was a case called Bragg versus EAA. And these facts were, let me tell you, as a lawyer, you want to be very careful what cases you bring forward, right? Like everybody's thought about, like, you don't want to go against the sweet old grandparents that show up in coveralls and things like that. That was the Bragg family, right? They were adorable. The fact pattern was horrible. They had asked for all of this water and they essentially got nothing. And so they brought a takings claim. And as it was working its way through the court, the Day decision got answered. And so they got very excited and said, oh, great, now we know its ownership. And sure enough, they got a $2.5 million takings verdict plus interest. So the Edwards Aquifer Authority had to pay them $4 million for denying their permit. Interestingly, based on the reason they denied the permit was the Edwards Aquifer Authority Act that the legislature passed told them that they could not give the Braggs a permit. So they interpreted the statute exactly correct, but it put them in harm's way because now with this new case law, that was a takings. So, anybody exhausted yet? There's more. There's a whole other level of this. All right. So that's the law, right? So people say like, what's the law in Texas on groundwater? It's like, well, how much time do you have? And so the easy answer that you hear is absolute ownership. You can tell already that's not accurate, right? So the real answer, if you ever want to play a lawyer on TV, is it depends on where you live. Because if you live in an area without a groundwater district, that is the right answer. But if you live in one of the, how many groundwater districts do we have now? Okay, if you live anywhere within one of the 98 groundwater districts, there are 98 different answers to that question. And so the legislature also realized, this is going to be tricky if we have 98 plus whatever all these individuals are doing if there's no groundwater district. How are we going to ensure that an aquifer isn't totally empty over time? So in parallel with this, so here's the legal property rights regime, but then we also have some groundwater planning going on, right? So this is on top of this and definitely involves the groundwater district. So I'm just going to talk a little bit about this so you understand the sea of acronyms that we use. Water people are worse than the military in acronyms. We can have whole conversations and never use a full word. And so this is what we have. Okay, so many of you have maybe seen the state water plan or heard about how much money we need to fill all of our water needs. So on the left are the state water plan regional planning areas, right? So these areas are supposed to figure out how much water they have, how much water they're going to need based on who's going to be moving there, and what is the delta between that demand and their existing supply. And then they have to propose how they would meet that delta, if there is one, right? So many of the high municipality areas are saying, oh my God, we have this much and we need this much, right? And other areas are having, some of the rural areas are having people leaving, and so they actually they have a surplus. So groundwater has to be part of that conversation because the water, one huge part of the water resources for any given regional water area is going to be the groundwater. So the state divided us up into groundwater management areas. Here's your first acronym. We call them GMAs. And if you think back to the groundwater district map that I showed you, I will not bore you with deleting my way back through it, but this mimics, these shapes mimic much closer to aquifers than the individual groundwater districts, many of which are single county districts, right? They've been around for a long time. And what they said was, they said, districts, you need to get together with the other districts in your groundwater management area, your GMA, and you need to come up with acronym number 2, your desired future conditions, your DFCs. All right, what the hell are those? Here's how I explain it. You want to retire someday. You go meet with a financial planner and you say, I need to have enough money in my bank account to be able to retire. The first thing that person is going to ask you is 2 questions. How old do you want to be when you retire, and how much do you want to pay yourself when you do that, right? There is no way for you to know how much money you need to put aside every year unless you know what your outcome is going to be. That is essentially what Texas asked these different GMAs to do. They said, get it together, figure out what you want your aquifer to look like in 50 years, and then we'll work backwards. Well, we could talk all day about whether or not this was a good process or not, or is a good process, because it's ongoing. There were a lot of different answers that people came up with, right? There were districts that said, we want it to look exactly like it does now. The Ogallala did what we call the 50 and 50, right? It's okay, we want it to be 50% full in 50 years. The Edwards already we knew what we had to do in the Edwards because the federal court had told us to. So now you know your goal, right? So you tell your financial planner, I want to retire in 20 years and I want to be able to pay myself $60,000 a year. What do I do? So they have to do some math and figure out how much you need to be putting away each month or year. That's basically what happened. The Texas Water Development Board took those goals and they ran it through their models and they said, all right, for this GMA, if you want to hit your target, you need to not be giving away more than this amount, right? And so that was supposed to then translate to permits, right? So remember that Edwards was the only one that had a firm cap. And so the question started to come around, hang on, if the districts are meant to hit these DFCs, then they ostensibly may have a cap too of how much they can give away in order to hit these targets. And so we're sort of in this quagmire still, trying to understand this. And what if one groundwater district is very generous about giving out permits and the other one isn't, right? So those of you who have children, back to the financial thing, you know how much money you need to put aside. You give each of your teenagers an ATM card, right? And one of them may be very fiscally conservative and the other one isn't. How is that going to impact your financial goals and how much money you're going to put aside to save, right? This is the challenge that these groundwater districts are sort of facing at this time with this takings danger over here, right? Because we already know that they likely cannot say, no new permits. We can't give any new permits or we won't meet our goal because someone's going to say, but I own the surface water, the surface estate, you can't tell me I can't take any groundwater, right? So that is the complexity of this. So most of these I've already gone over, is that we have this issue of desired future conditions, is it modeled? Modeled, if we keep changing the word now, modeled now. The modeled available groundwater is what the Texas Water Development Board comes back with. This is how much water you have to play with in order to hit your desired future condition, right? And then somewhere in there, these groundwater districts are tasked as a whole in each groundwater management area to make this happen, right? Not easy. Oh, and by the way, we don't give groundwater districts very much money to do any of this, right? And we have tons and tons and tons of missing science. Because as you heard this morning, several people said, why don't we have studies that are more recent? There are places that we don't have studies, period, ever. And so this is very, very challenging. So the last layer is that within groundwater, there are things that we do not regulate. And this adds to the challenge of meeting these goals that we have. So the first thing this is our exemption statute for groundwater. The first thing is domestic and livestock wells are exempt. I think we would all agree that that's probably a good idea to some level, that if you own land, you should be able to get water for your own personal use or limited livestock use. I would, however, challenge you to think about that number of how much water is exempt on a daily basis, and ask yourself, if you are planning, if you're in charge of that groundwater district and you have a goal and you have a bunch of people that are exempt from your permitting, all taking out 25,000 gallons a day, how effective is your planning going to be? So again, imagine your financial planner goal and you've given out an ATM card and you're not asking them necessarily to report back at all how much water or how much money in that case they're taking out. So this is another challenge. Some groundwater districts do permit these. The Edwards says, look, we're not going to say no to you because it's an exempt well, but we do need to know how much you're actually taking out, and we need to know where that well is. Not all groundwater districts do that. The other one, and this one is extremely controversial, is this is the statute that everybody cites when they say fracking wells are exempt from groundwater permits. Another conversation that we had over lunch that I would love to have again is whether or not that's actually true for fracking, because it all lies in what does it mean to drill, what does it mean to explore, and what does it mean to produce, none of which are defined by the law. But some groundwater districts have decided that that is not fracking, that that's not what that's talking about, and that they should be able to permit. Other groundwater districts have said, you know what, that's an exempt well, we're not interested. Again, in those districts, we're handing out ATM cards, and we don't know how much water is coming out. The other thing that we do not regulate that came up today, so here are just some numbers of shale plays, you guys have seen this. It can add up to a lot of water. This is the other one that we talked about this morning that we do not regulate. So Comanche Springs is the case for this that says, if you pump a bunch of groundwater out and those springs stop flowing, that's okay, because you had a right to that groundwater. Now, obviously, if there's an endangered species or there's another law that gets triggered when you do that, that may be different. But from a straight groundwater to surface water relationship, that's not an issue. So this is super challenging in Texas. If anybody's heard of Jacob's Well, there's an area there where that is groundwater at the surface, and then it runs down a river, right? So when it's groundwater, it's regulated in the ways that we've just discussed. Then it reaches the surface and goes onto a creek. Now suddenly it's surface water that's permitted, and then it hits a recharge feature and dives back down underground and becomes groundwater again under these laws. And so there are lots of interesting legal issues to this. Having a surface water permit is also a property right. That is something that you own once you get it. If I pump all of my groundwater such that you cannot use your property right now we're saying there's no liability between us. I would look to see some people challenging that in the future. And of course we have groundwater feeding so much of our Texas rivers. So we cannot ignore groundwater when we're talking about healthy rivers, basin estuaries, and environmental flows, which we'll be talking about next. This is again where science and law are not talking to each other and not getting along very well, because the scientific reality is you cannot separate these two items. If you want to be successful, if you want a healthy ecosystem, if you want all people's property rights to be recognized, we have to figure out a way to legally discuss those together, and right now we just don't do that. So we do not regulate that at all. Here's of course the famous pictures that a lot of people have seen. These are the pictures that worry people about Valmarais and other areas like this. You know, if you go back and read old history books, you know, Comanche Springs was a beautiful resort, and in a matter of very short order became dry as a bone. And in that case, the law said, that's okay. That was their right? That was the Williams family's right. And that is still the standing law when it comes to surface water and groundwater. So I have no idea how much time I just took, but that is it. I am happy to answer questions. My email address is there. You can always reach me. I'm always happy to talk about water law.
Let's give her a hand.